So even though we've got this situation, and even though we have a situation where it at least appears that some of the parties involved are not going to insist on limits of liability in certain circumstances, that doesn't mean that all of the problems that exist in maritime law regarding limits of liability are dead. That means that these issues need to be understood, and they need to be understood in the context of this particular controversy, because now we have the spotlight shining on them. Now we have a chance to understand exactly where the weaknesses are in OPA. Now we have a chance to understand exactly how OPA might work out to interact with the Limitation of Liability Act and Supplemental Rule F of the Federal Civil Procedure. What we're really talking about here is a defense which certainly has an impact on the public mind. Anyone who read the press and listened to the outrage over Transocean's filing of its Limitation of Liability Act knows that these sorts of limitations can cause some serious problems in public perception. But you know, the truth is about oil. When we talk about oil and we talk about petroleum, it's all about, relative risk, isn't it? Isn't that what we're all talking about? Everyone in this nation and on this planet puts their hands on petroleum. And so the benefits and the risks associated with petroleum necessarily are visited on everyone. What is the real purpose of having liability limits in the first place? Well, back in the old days, back in 1851, when the Shipowners Liability Act was passed, that was a time when we really didn't have sophisticated and mature insurance markets. And those markets really were inadequate to protect shipowners against large-scale risks, such as losing a vessel or the death of crew or losing the entire cargo. But, it was also designed for another purpose. Like any other law, it's a product of compromise. It was designed to protect the American shipowners from competition internationally. Because guess what? Britain and other countries were enacting limitation of liability statutes. And so if American shipowners were out competing with the British, and the British had liability that was limited, and the American did not, well, the competitive effect on American industry. And that was one of the purposes of the Shipowners Act. And it's not talked about very much because people like to say, oh, it was all about insurance. Well, it really wasn't all about insurance. It was about a political compromise that came to pass. And so later on, limitations came about once again, and they came about in OPA. And again, these were political compromises. They were designed to accommodate the need for exploration and production of essential products, and make no mistake about it, those products are essential in our society, and to provide some degree of compensation to injured parties. Now note, I say some degree, because under no sense can anyone say that a catastrophic situation, certainly as what we have now, and God forbid we should ever have again, is covered adequately by the Oil Pollution Act. It is not. It is not covered adequately by the Oil Pollution Trust Fund under any circumstances, assuming that the limits of liability apply. So what really happened in the Oil Pollution Act was, by establishing and funding a compensation trust, it was really designed to promote prompt resolution and prompt settlement, and to decrease the burden of litigation and the delay of litigation and the cost of litigation that went first.